So running a major conference is more like a marathon than a sprint. And you guys are to be congratulated for being wide-eyed and excited still for the last panel. What we try to do is find the most controversial topic and put it at the end of the day to keep everybody up. And this has been a really controversial year for the International Criminal Court. So we think this is going to be fascinating for you. You've met Jim Johnson. I introduced him earlier. Let me just turn the panel over to you.
Thank you, Michael, and I'd particularly like to thank you for giving us the 4 p.m. slot on a Friday afternoon, and so we really appreciate that very much. I think the panel will do their best to keep everybody going for the next 60 to 75 minutes. But first, let me just briefly, and my introductions are never long, but let me briefly introduce the panel that you have before you here today. Of course, you have Todd Buchwald, my German pronunciation comes out once in a while, former ambassador and head of the State Department's Office of Global Criminal Justice, and I believe now a resident scholar at the Woodrow Wilson Center, lecturer at George Washington, and many other things as well. Sitting next to Todd, you have David Crane, the founding prosecutor for the Special Court for Sierra Leone, a long distinguished career as an Army Judge Advocate, Senior Executive Service, and Professor of Practice at Syracuse Law School. And next, of course, we have Melina Stereo, who was introduced earlier, Associate Dean at Cleveland Marshall College of Law, Liz Evanson, Associate Director of International Justice Program, Human Rights Watch, and, of course, Alex Whiting, Head of Investigations for the Special Court for Kosovo, and, I believe on leave, Professor of Practice at Harvard Law School. So you have a very, very distinguished panel before you today. Please give them a quick round of applause. As Dean Scharf has indicated and kind of implied in the title of our panel today, Threats and Challenges Confronting the International Criminal Court, I guess that means that we're concerned that there are some threats and challenges before the International Criminal Court. I think that's probably safe to assume. This, in some ways, hasn't been a good year, or hasn't been a good few years for the International Criminal Court. We've had a few high-profile acquittals. We have states threatening to withdraw. I did hear in the last few days that a bill is being introduced in South Africa to leave the International Criminal Court. You have, of course, the Afghan investigations was turned down. You know, the U.S. is essentially, well, the former National Security Advisor, but I don't think that's changed today, probably. The U.S. has essentially declared war on the International Criminal Court. I think wouldn't be an overstatement of that. And so there's certainly a lot going on. There's certainly a lot of concerns going forward with the International Criminal Court. Where will it go? Every now and then you hear say, you know, maybe the International Criminal Court should go the way of the League of Nations. Maybe we should just dump it and start all over and see what we come up with. I don't know that anybody on this panel has ever said that. No, of course not. But anyway, and so, you know, we were kind of thinking, well, we're the last panel of the day, and we want to keep some discussion going, and I'd like to see a very free-flowing discussion between our panelists, kind of get their thoughts out, and even rooms for some questions. And, you know, I'm not one that always says, let's save the questions and let's take the questions at the end. If you have a question, if someone says something, I don't mind you raise your hand and let's get it out at the time, because again, let's try and keep this a very free-flowing discussion. About a week ago, I asked the panelists, how should we start out? Or are there any questions you would particularly like to deal with? And it was Alex that came back to me and said, you know, let's have a lightning round where each of the panelists go down and give their what they see as the three biggest challenges facing the ICC today, and then we can take that and run with it a little bit. So let's start. And of course, the one that starts has the easiest time, because that way if someone else says that, you know, you have to find a new one. But anyway, so we're going to start. We're gonna start with at the opposite end of you. You're being punished for coming up with the idea. Is what's happening here.
What's that about?
Todd, let's
That'll
start
teach
down
you,
there.
So thank you, Michael, for the 4 o'clock slot, and I have my little dram of coffee here still, and I hope you can all bear with me here. There have been, many sort of things that are seen as setbacks for the court in the last period. The Gbagbo no case to answer, the Afghanistan decision has drawn a lot of criticism, the overturning of the Bemba conviction and so forth. But I wanted to take just a little step back and sort of think of the challenges in more thematically, the things that are sort of facing, make the environment hard for the court. And the first one that I'm supposed to have 3. The first one is the mismatch between the court's expectations for the court and what it could plausibly be expected to achieve, no matter how well reformed it was. And the mismatch is important because it leads to inevitable disappointment for victims. The court can't deliver all the things it's being seen as promising to deliver. Disappointment for justice advocates, and in a way, most important, the sense of disappointment disempowers those who would support it within the government, and I assume within other governments too. And the diminishing support is, here in the United States, it's its own story, but it's not just happening here. There's a strong ebbing of support for the court. The second thematic thing I had was sort of under the heading of prosecutorial discretion. The court has built into it sort of many elements, many ways that it sort of mechanisms that it tries to use to sort of sift through which cases it should pursue. They're in the basket of admissibility and admissibility-related elements of the way the court chooses situations and cases. Gravity, complementarity, interest of justice. For them to work in a way that sifts better requires, I think, a large amount of prosecutorial discretion. And the way the world is sort of set up now, the tolerance for having these things decided by the discretion of the prosecutor is diminishing. And the third sort of theme that I would put on the table is sort of the loss of the magic moment theme. And I hear many people talk about sort of that moment in Rome when all this was possible. And, people often will say, and we have to preserve what we have because we couldn't really recreate it today. The sort of, the end of the Cold War and the sort of optimism about accountability isn't there. And that's, I think, correct. I think a problem, though, is that in the Rome Statute, there was a sort of generation of first-level issues that were resolved in this moment of optimism, and we're now facing a second-level generation. And the consensus with the sort of sense of optimism, the magic moment that brought the international community to sort of a consensus in 1998 sort of isn't there anymore. And it makes it much harder to sort of come up with a recharting that I think is necessary for the court to succeed. From the U.S. point of view, of course, the relationship of the U.S. to the court, the challenges are more tangible. They're whatever happens in the Afghanistan case, whatever happens in the sort of Palestine situation, I think will, both of them have the potential to sap any oxygen, even in a otherwise more sympathetic administration to the ICC, any political space for developing a sort of a positive relationship from the court. So as a former U.S. government employee, I sort of, I can't help but watch that. Those are my 3.5 lightning rounds. Lightning rounds like on Jeopardy or something, isn't it? Yeah. So anyway, thank you.
Well, you didn't put it in the form of a question, but okay. Next, David.
Well, I like that, the magic moment of Rome, and it really was a magic moment, and the applause and the tears and the hugs and just the possibilities were amazing, and it was thrilling actually. We had an amazing international statute, the Rome Statute, which defined all sorts of things that we've always wanted to have. It crystallized a lot of ideas. We have over 120 nations who are states parties. It was created in the age of accountability. It was a heady time. So what the hell happened? That's a question, Jim. But it doesn't count for my 3 points.
So you still have 3 to go.
I do.
Okay.
One thing is, as we talked this afternoon, I don't want anybody to come back saying, well, it's a new court. It needs to work. It needs to stretch its wings. It needs to find its path and its way. It's been 2002, and that's no longer a credible counter-argument as to the credibility of the International Criminal Court. And I approach this as a believer in the court, someone who loves the court, who has great respect for the wonderful people who work and have worked in the court. That's not what I'm saying here. But let's drop the argument that it's new, it's establishing itself, it's working its way and spreading its wings. I don't buy that anymore. Points. The International Criminal Court is form over substance. I've never seen so many good people work so hard and create so little. Track record. It is what it is, and it's not good. And that is a real problem for those of us who advocate for the International Criminal Court and for accountability, because they always throw the International Criminal Court track record in my face. And it's very difficult to counter that, because that's how people look at it, results. Another point, there's a perception, not within the court itself, but looking at the court internationally, of a malaise that has set in. It's just getting up, going to work, and going home at night. And that's subtle and insidious. And my fourth point...
Wait, you're only allowed 3.
I know.
As the last person, I have an interest in limiting you to 3.
You can have 3.5.
Okay, well, this is 3.5. They have terrible political judgment. I'm a believer that a chief prosecutor who was a chief prosecutor, politics with a small p is very important in developing your prosecutorial strategy, both globally and on particular cases. You've got to factor in the political implications of what you're about to do. Thank you.
Sure. So 3 points, not 3.5. I'm sticking to the rules. The first one is actually something that David already said, that the ICC has had a weak record of convictions. So this might be just a perception that it's not doing a good job, but the reality is that for a court that costs a lot of money, it hasn't actually delivered a large number of convictions. And I'm sure we'll get more into detail, about this point. The second challenge I think that the court has faced, in particular recently, is that there is this perception that there is a discord among the judges, that the judges have a hard time coming to agreement as to some of the basic legal rules, to say the least, and that in some of the judgments, we see this discord among the judges where the judges just cannot seem to come together and deliver sort of unified judgments where more than 2 people agree on something. There's also obviously this, sort of news that's not news about judges some of the judges suing over their salaries, and that certainly, whether they're right or wrong, I won't go into that, but that certainly doesn't contribute to a positive perception of the court. And then the last point is that the court has had a difficult relationship with the U.S., a difficult relationship with some of the other, great powers, and that certainly makes it very difficult for the court to be successful in cases where, for example, you might need the Security Council, right, where you might need the assistance of those powerful countries.
Okay, so first of all, I wanted to say thank you very much to Professor Scharf. It's been wonderful to be here. I will spell out 3 challenges that the court is facing right now. I think just to say one word before that about where I'm coming from in identifying these challenges is that I think it's true that the last 14, 15 months there have been a lot of bad news stories about the court, but I see it more as these were problems that have been a long time in the making, and they've been surfacing more visibly, but they aren't really new to the last 14, 15 months. The exception, I would say, is the decision on Afghanistan, which I think was shocking, and I think was something new in terms of susceptibility to external interference and also a result of a long campaign of pressure from states on the court's budget and an absence of support. So for me, that was new. But the rest of these challenges, I think, have been with the court for a long time. The first is the challenge that the court has of building for every new situation it takes on, and it currently has 11 situations, and it could certainly have more. For every new situation, it has to build the political support. It has to build a political consensus to act, and it has to build popular legitimacy for it to act, particularly with victims and affected communities. And it can't take either of those for granted, and no form of trigger as a guarantee of either of those. I mean, Security Council, state, proprio motu. So how do you do that as a single institution? How can you create political support, popular legitimacy, having to do it across multiple, very different situations? The second challenge is that it has a workload in terms of what the Rome Statute criteria permit it to take on that is far in excess of the resources that it has. And so what we've seen is the response to that from the Office of the Prosecutor has been to really overly prioritize and bring a very small number of cases in each situation, which I think has only doubled down on building the political support and the popular legitimacy that I mentioned before. So a workload that is just completely out of line with what the international community has turned out to be willing to pay for international justice. And the last is adapting investigating methodologies to circumstances that I think are really rather unique. And I would really welcome the views of the rest of the panel, because I focus a lot on the ICC. But I'm not sure that the cooperation regime within the Rome Statute is extremely weak, and the places and the kinds of things that the ICC is trying to investigate are, I think, very different from the conditions that existed to investigate, say, in the former Yugoslavia. So how do you do this work in places where, again, you won't have a peacekeeping operation, you won't have a Security Council mandate, nobody may want you there, they may have wanted you there in the beginning, they no longer want you there. How do you actually do the practical work of investigations under those circumstances?
Okay, my three will kind of echo some of what's been said already, but maybe with a slight twist to it. The first one is that there's a lot of attention paid to management at the court, and whether cases are being managed well, whether it's in the prosecution, and quality of the prosecution, quality of the investigations, quality of the judges. But I think in the last year or two, there's also emerging, and this is my first one, is a sense of perhaps challenges of institutional design that are really more fundamental. And this echoes a little bit what Liz has just said. And you might say that the court, what I think is becoming clear is that the court's built on at least two fundamental tensions or contradictions. The first one is that the International Criminal Law Project, and this has been echoed throughout the day, you've heard this, has pushed to expand accountability, to expand the reach of the law, right? The crimes against humanity has been expanded to cover more types of situations, more crimes, to expand jurisdiction, that the International Criminal Court, of course, expands jurisdiction, to expand modes of liability. We were talking earlier about whether outside actors could be held accountable under an aiding and abetting theory in Yemen. So it's about expanding the reach of accountability. However, what's becoming clear is that to be successful in prosecutions, you need intense focus and concentration. And so the court is pushed to cover lots of situations, lots of crimes, lots of possible modes of liability, and therefore unable to devote the kind of focus and concentrated attention that has proven successful at the ad hoc tribunals, for example. And here I actually disagree with Todd. I think the problem is that the prosecutor has not exercised enough discretion to narrow and to focus on cases. And the second contradiction, and this is a really fundamental contradiction that's baked into the design of the court, is that the court, as Sean was saying earlier, the court can only act when states are unable or unwilling to act. It's a principle of complementarity. But then when they're called upon to act, where do they turn for resources and cooperation and evidence? Well, those very states that were unable or unwilling to act in the first place. And so they're asked to do this task depending on actors who are unable to do the task, and therefore so there are challenges of institutional design. The second challenge is one that doesn't get enough attention and is rarely discussed, but I think it's a human resources problem. And this maybe touches on the malaise thing that David said. One feature of the ad hoc tribunals is that they were ad hoc. And people who came to the ad hoc tribunals knew that they were ad hoc. They came there, they knew that this was not a permanent job. They came for a short time. They came with a lot of energy. They came to make their mark. They came to do something in a few years and then go home. At the international criminal court's a permanent institution, and people are staying, and they're making a career of it. And I don't think that's a healthy thing for the institution. And there's a lot of discussion inside about a culture problem and a malaise, a lack of urgency within the institution. And then the third problem is that the court has simply done and is doing too few cases. And this I'll echo what David said. The court is incredibly busy. People work very hard there, at least during working hours, and yet they produce very little. They're working on a lot of things, but maybe not the right things. And the court has, and we can talk about this more, the court has to do more cases if it's going to succeed as a court. It has one case in trial right now and 2 cases in the pipeline, and that's it. It has got to do more cases.
Before I kind of throw out the first comment, I might disagree with you on one thing that you said, Alex, and you said that those coming to the ad hocs come with a lot of energy and wanting to get the job and done and go home quickly. I can say not everyone in the ad hocs feel that way. I think David might agree with me that if everyone did feel that way, I wouldn't have been in Sierra Leone for nearly 10 years. I would have been there for a much shorter time.
10 years is still not a lifetime.
No, that's true. Felt like it, but okay. I want to comment, and it kind of a lot of you mentioned it in a way, but you look at the budget of the ICC is now. I think a couple years ago it was 150 some euros a year. Does that sound right? In 2016, I think 158 million, something like that, euros a year. And people look at that and say, well, for that you have 9 convictions, I think. So and that's 150 million euros a year to get 9 convictions. But yet your comment was that I believe you said that. That the workload they currently have is in excess of resources. And Alex, you're saying that I hear someone saying that they need to expand a little bit in what they're looking at, and then I hear some that we need to focus a little bit more on what we're looking at. And so I'd kind of like to bring that together and discuss and understand just what you mean when you talk about that. What should they do? Should they be more focused? Should they be expanding what they're doing? We need more cases. We need more convictions. And so I just kind of throw that out a little bit for discussion. I noticed some contradictions in what each of you said along those lines. Sure, please.
I don't think, and they never have had, a coherent strategy in general or specifically for each case. I've never understood it. I think it's critical that you have that. When we were putting together the International Tribunal in West Africa, the Special Court for Sierra Leone, I created a general strategy of how we were going to start the court, where we were going to be in the middle, and where we were going to be in a number of years at the end of the court. Also, I had a specific strategy for how we were going to prosecute the various cases. That leads to efficiency. So I'll just leave the point is that to be successful, you have to have a general strategy, a general concept, which was not created with the first prosecutor, and it's carried over to the second prosecutor. I know that they're working through these, and many of us have assisted and advised on what we would call strategy. but just simple, or just concepts of approaching how do you get and decide on a particular case, who you're going to prosecute, when you're going to prosecute, why are you prosecuting, where do they fit in, what's the political implications of that particular prosecution, being aware that should I indict someone, particularly a head of state, I might want to think of going around quietly in the region and discuss the concept of that, not getting into details of strategy as to what that means to the region. And I think that if they do that, or they try to work at this and keep it in a four corners, a way where everybody understands who they are, why they are, where they're going, and why they're getting up every morning and coming to work, it makes it more efficient, more effective. And what it ends up doing is you shrink the number of cases that you have based on the strategy, and you become a lot more effective in doing that. Plus, politically, then, you can go back out to the state's parties, various other constituencies, the NGOs, which are very important, and most important of all, the victims, and explain to them why you're doing what you're doing. And as a footnote, we might want to talk about victims in the International Criminal Court and their relationship with victims in their investigations. But I'll just leave it at that.
Actually, I very much share that view. I think one thing that we have often called for is for the court to be developing in each situation what you could think of as a completion strategy. But it's a misnomer, because actually it's something we think needs to be there from the outset. So when a new situation is opened, what is the vision for that situation? How many cases are going to be brought? What kinds of cases? And that there should be a prosecutorial program from the outset, one that will have to be adapted, that will change the situations of ongoing conflict, but at least starting with that program. Now, I think we have seen some kind of progress towards that. Alex, I think you and I were in a panel in 2012 or something like that, and we were talking then about the idea of completion strategies. And now this is actually something that the current prosecutor has said that she hopes to start to pilot in at least a couple of situations before the end of her term. We think they have to be actually court-wide completion strategies, because part of the vision should be what will the court being able to say it's finished its work in a particular situation look like? And that will probably require being able to transfer responsibilities to national authorities, or making a decision that that's not possible. And that will really involve all kinds of court functions, not only what the Office of the Prosecutor does, and bringing in states parties as partners as well in capacity building initiatives. But I do think we've seen under the first prosecutor an approach of selecting one case per situation, then perhaps coming back later on and deciding on another case or not. And I think that it needs to go from that, which I think we are seeing some signs of it in terms of the office now talking about prosecutorial programs and completion strategies. They have a new policy on case selection and prioritization. Again, I think that's a step in the right direction. I think at least now they're able to better identify, I think I saw in some of their documents, they have 40 plus cases that they think they could do in the situations they have open, which is what leads me to say that they don't have the resources to match that workload. At least now they're sort of able to survey what would be the scope of work that they could do and to make choices based on that, whereas I think in the earlier days they didn't necessarily even have that overview per situation. But going from all of this to a really strong, articulated and coherent vision of what does it mean for the court to complete its work in a particular situation, I think will help then backfill into these decisions from the outset.
So I both agree and disagree with what Liz has said. I agree that trying to find a way to end situations and what is how you close a situation is a major challenge. And it's not obvious how you do it, because if the court only does a few cases, then do they say, well, we're done here and move on? That's a hard challenge for the court. Where I think I disagree is the notion that at the beginning of a situation you're going to be able to devise a coherent strategy about where that situation is going to go, because the thing that you and this I can say from having worked at the court, the thing you really feel when you work there is that the court is not in control of its own destiny. and therefore that it's too dynamic and fluid, and things change. So, for example, I was there when the Libya situation was referred to the court. That was completely unexpected. That was not planned for at all. So, not planned in the budget or anything like that. All of a sudden, the Security Council, by unanimous resolution, United States included, sends the Libya case. That becomes a priority, right? And then, for the first time ever, there's states that are literally calling the court and asking how they can help. So it seems like, okay, not only is this a priority, but we're actually going to be doing something. The prosecutor was prescient and said, we have to move quickly because this support will not last. And he was right. 6 months, nobody cared anymore about the court and about the referral. And we had brought indictments against several people, including Gaddafi and his son. And then all of a sudden the support and the interest dried up. So trying to figure out what you're going to do and how you're going to, how a situation is going to unfold is often highly unpredictable. The thing, while I have the mic, the thing I would say is what I would say the court needs to do, as I said, is do more cases, and I think a lot more cases. And I think that would force the court, the judges, the registrar, the whole institution to become more efficient. The ICTY ran 6 trials at a time, often multi-defendant trials, sometimes 7 trials at a time. The ICC could do something close to that, and it would force everybody to work more efficiently with the resources that they have. Now, it would mean probably doing smaller cases. And I think that's what they should do. I think that's what I think the number one strategy for the prosecutor should be do more cases, do smaller cases. There'll be criticism, and we can talk about that, but that is the only way I see for the court learning how to establish itself as a court and function as a court, and then it can move on from there.
If I can just quickly jump in. Yeah, just picking up on Alex's last point, I disagree with many of the points that were already made, and I would just add to Alex's last point that if you think of the ICTY, it started, the very first case in the ICTY was Duško Tadić. He was a no one. He was really, this low-level defendant, and the ICTY ended with Karadzic and Mladic, the highest level defendants. And so I do think that would be a winning strategy for the ICC, not to start at the top, but that within a given situation, it should start with perhaps a middle level offender. And as you correctly said, some people might disagree with that, but it might be easier to build the case against the president or prime minister of a country if you start at a lower level.
I mean, I obviously think that you need to have the evidence to bring those higher level cases, and that's one thing that I think that those have been mistakes that have been made by the ICC. I'm not sure that you need to bring all of the cases. I think you need to investigate them, but I'm not sure that you need to bring all of the cases into court. And I think in an ideal world, it would be great to have 20 years for each situation to be able to get to the number of cases that were brought for Yugoslavia. But I think that's why it comes back to one of the challenges I mentioned at the outset. If the political support was gone on Libya within 6 months, unfortunately, you might end up with a situation, which I think is the current Democratic Republic of Congo situation at the ICC, where you could say those were small, narrow, low-level cases, ideally would have built up to actually bringing cases against those who really called the shots. But because other demands came in, because there weren't resources, because there were problems in those investigations as well, we have a situation where quite likely, unfortunately, I hope not, we're still calling on the prosecutor to do more cases for Congo, but that might be the sum contribution of what the ICC has done. So I think I agree, but I think practically speaking, how do you give the court enough time, enough support, enough resources to kind of have that extended track record that we saw with the Yugoslav Tribunal?
I think this is incredibly important of talking all of these issues and bringing out all of these perspectives. But I have to respectfully disagree on some of the points, taking from a chief prosecutor who actually founded a court and actually created a specific strategy on how to prosecute all of the defendants in a region of the world, and actually planned it out in a way that was effective, efficient. And so I think it's critical, and I disagree that it's too hard to do. You can't do it. Yes, you can do it. I'll just give you a little vignette. There were only two chief prosecutors in the world when I assumed my duties. I was the second. Carlo Del Ponte was the other chief prosecutor. So as I was traveling to Sierra Leone the first week in August of 2002, I stopped by The Hague to pay my respects and just get to meet the senior members of the court, paid a visit to the judges, what have you, and I would go to Rwanda a little bit later. And so I had a meeting with Carlo Del Ponte and her leadership team, and I said, well, look, what I'd like to do is I'd like to give you my general strategy, my plan as to how I intend to prosecute in Sierra Leone, and then I'd like to kind of give you my general prosecutorial strategy. And I laid it all out for them, and I said, I'd really like your perspectives, Carla, and I'd like to know and see perhaps after this meeting if I could see your strategy. There was a very pregnant pause, and so, you know, what do you do at that point while you're standing in front of everybody with all your charts and your steps, and here's where we're going to go, and I was actually briefing the Security Council saying that I expect with appropriate political support that we should be done with our work in 6 to 7 years, and here are the steps that we're going to take, boom, 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 boom. Here's where I'm going to be the first year, third year, fifth year, what have you. It can be done, and it should be done. And it can even be done with the International Criminal Court based on the cases that they're given. They can go through that analysis. They can think that through from a political, diplomatic, legal, practical, and cultural point of view as to how that particular set of cases in that particular situation, that atrocity, can be done. They're not doing it. But we did that in West Africa, and it worked. So, truth be told, I'd just finished my first year, and I was invited to the brand new International Criminal Court, and was asked, how did you set up your cases? And I told them exactly, and I briefed them the same way as I did to Carlo Del Ponte, and they didn't follow any of my recommendations.
When the phrase "the cases that the ICC is given" sort of goes to the heart of the problem. The Yugoslavia Tribunal didn't have to justify that it was focusing on former Yugoslavia. The Rwanda Tribunal didn't have to justify that it was focusing on Rwanda. The key thing that the ICC has to justify is how it picked these countries. And I'm not sure that it's quite. I have to think more about what Alex's suggestion, but I have a feeling in my bones that picking smaller cases, which I get from a prosecutor's point of view, runs in tension with having to justify how you pick these countries, by going after a bunch of small people, and or small fish, I guess. And I think that way of thinking, which I get, I mean, it's sort of like what an American prosecutor would do in an American case. It sort of depends, again, on sort of like, trusting prosecutors to make right choices. And at this juncture, the ICC isn't in control of its own ship, and in fact, most multilateral organizations aren't in control of their own ship. At this point in just where the world is, and the sort of, people throwing sovereignty around, and Brexit, and the current administration and so forth, I'm not sure that the leash that's necessary that the prosecutor would need to have to sort of do that strategy is sort of available politically. I don't know that for a fact, and it's not from the United States, because the United States isn't one of the people who's controlling the leash at this point. But I just sort of wonder about that.
Well, I don't mean to suggest that you would give up on big cases, or you give up on senior people, or you give up on the possibility of building towards, in some cases, though that's not always possible, because as Liz says, the political will is not always there. But the thing is that the thing you have to think about here is, and this goes back to Michael's utopian question, is what you're choosing between, right? If you're choosing between, let's go after the senior leaders, the most responsible, we can get them, and we can get them into court. That's obviously the thing if you could do that, you would do that. But if the choice is between empty courtrooms and having cases, I'll take the cases. Because I think that yes, there will be, if you do small cases, there will be criticism, and if that's all you do, there'll be a lot of criticism. I think there'll be more criticism if you're doing nothing.
Yeah, but you also have to. Why are you prosecuting this big fish or small fish? And how does that fit in the overall plan for that particular atrocity? And also, does it fit in with the general strategy related to how we decide on who we prosecute? They don't ask the question why, they just do. And sometimes that doesn't work out.
Lena's
Yeah, Layla and Jen both have a question. Actually, I saw Jen first, and I saw Layla. So, Jen, did you have a question?
You guys are throwing a lot of darts at this institution. I don't disagree with many of them, but I think you're not looking systemically at the responsibility of others. So I wonder if you would comment on, the court gets 2 referrals. It didn't ask for them, but they come with no money and they come with no backup. The court has a lot of outstanding arrest warrants, and that's not the court's fault. That's the state parties. So what we're seeing is, I think a lot of the difficulties you identified do have to deal with the court, but the court operates in a system where it relies on state cooperation, and I think some have talked about, these are countries where they're unwilling or unable, and then you have to turn around and get their cooperation. So it's an incredibly challenging political environment. So I think, experience has taught us when a tribunal has to just prosecute in one situation country, in hindsight, it was a lot easier to do just Rwanda, just Yugoslavia, not the world. But I do think this panel's focused a lot on the ICC, but it's the ICC in this context of relying on state support, the Security Council when it makes referrals, and a system of cooperation, and ideally a system in complementarity. I mean, I actually thought when they created the ICC there would be more investment in domestic systems to conduct the remainder of the prosecutions. So I wonder if people want to comment kind of on the broader picture.
Let's take the next one.
Thing, which is every 3 years the prosecutor issues a comprehensive strategic plan, and there's also a document called the Policy Paper on Case Selection and Prioritization, which sets out very, very clear. So I don't mind discussing, okay, maybe the strategy is not working or et cetera, but actually the office has been unbelievably responsive. I am a special advisor to the prosecutor, I admit, but there are actually documents that very specifically address the office's stated priorities. So I just don't want the audience to think that there's sort of no attention being paid to this, because in fact there are documents every 3 years that are very detailed, and the case selection policy paper, I think, answers a lot of these questions. It doesn't fix the political environment or slow trials or not enough case, but I do think that the discussion maybe should be grounded slightly in what's actually happening in the court.
Well, let's go ahead and take a third one, and then we'll comment.
So at the risk of being outrageous, it sounds to me like between the lines I'm hearing that the ad hoc tribunals really worked because they were small, integrated, purposeful, supported, and so on, and that really is the better way to go. And I wonder whether you might want to convert the ICC into a venue for ad hoc tribunals. Are there any takers to that? The second question is for Liz specifically. You mentioned that you were surprised by the ruckus over the Afghan indictment, or the possible indictment. Could you explain your surprise? Because I'm also surprised. I don't know the narrative. I don't know the background. Thanks.
Okay, let's comment on Jen's, and I'd like to throw something in with kind of what Jen said, kind of related, but really about the political environment, and maybe address that a little more fully in general. Because, Alex said that, sometimes they're not in charge of their own destiny. And of course, risks or being concerns about the court being political is one of the major criticisms of the court when you get down to it, that it's going to be politically motivated prosecutions. And so kind of looking at the challenges and the threats to the court, those accusations are certainly a threat. And so what are some of the challenges going ahead in that direction? Go ahead.
Can I make one comment on Jennifer's? I tried when I sort of laid out my little, not to be critical of the court, but to say these are the challenges facing the court. the challenges facing the court include this political environment, include the lack of, and it sort of builds on itself, right? The lack of support makes the court, less successful, which makes for less support. And I think that the point isn't whether the court is to blame. The court is whether the situation into which the court is, of which the court is a part, is working. And the question was, what are the challenges to making it work? And those are the things that I think are the challenges to making it work.
And going forward, to Jennifer's point, I agree completely with what you say. I think that's absolutely right. The environment but going forward, I think that the answer can't be, well, we have to dramatically increase the budget, or we have to dramatically increase cooperation or national. That's just not going to happen. This court was created as we've talked about, at a high watermark, right? A golden moment, and even then, it was created as a pretty weak institution. It's not going to get stronger. It's not going to get more. So the challenge for the court is, how do you succeed given all those things that you have said?
I actually think, I don't think that any of us meant to sound so critical of the court, and I think it's important to recognize that when we start comparing the ICC to the Yugoslavia or to the Rwanda Tribunal or to the Special Court for Sierra Leone, it is apples and oranges. We're comparing the ICC, which is this court, designed to look at all these different situations. So in a way, the OTP, on Monday you're an expert on the DRC, but on Tuesday you're the expert on, Mali, and on Wednesday you're the expert on, Bangladesh, right? So that is much more difficult to do than when you're just dealing with, the former Yugoslavia or Rwanda or Sierra Leone. So, I think that, as Todd said, some of the challenges are not meant to be a criticism, rather an acknowledgement of the current situation. And then Layla said something I was going to mention, that yes, there actually is a prosecutorial strategy, and that we can quibble about whether it's, good enough, detailed enough, would you change something, but, let's not forget that it is out there. And I do think that the prosecutor has been very responsive to this type of criticism about case selection and the priorities, especially over the last 2-3 years. And I think that's a, sort of positive development for the court. And I also agree with Alex that it's perhaps unrealistic to think that, like, next year the court is going to have a budget of $300 million. That's just not going to happen. And that it is important to say, okay, given the budget, and perhaps the budget will decrease, right? It might be smaller. What can the court do? And I do think that there's something to be said about pursuing smaller cases, lower level offenders, and we can respectfully disagree on some of this, but pursuing cases where the OTP has a relatively high chance of success, so that some of these perceptions about the court not doing good work at least are, we can say, well, now we have 5 successful prosecutions as opposed to 1 or 2.
Thanks, Layla, for mentioning the documents. I mean, I think that's what I was really referring to in saying that now I do see, with the case selection prioritization, with the reference to completion strategies, that we're starting to get to a point. Nonetheless, I do think it's important that there be these situation-specific strategies, and they are exactly what I think everyone is just saying. It's because of the difficult circumstances that the court finds itself in terms of the lack of resources and the lack of political support, that I think it's actually probably more important than ever that the prosecutor or the court as a whole leads with a vision of what it's doing. Because I think another challenge or risk that we're really facing is that, given these problems, I think there is a real risk that states, parties will want to cut back on the ambitions of the Rome Statute. And it's important that those ambitions be preserved, and maybe it explains why a shift, which is actually in the new 2019 prosecutorial strategy to more narrower cases, is one that I'm questioning the reality of that. I'm questioning about, in the new strategy, it's posited as smaller cases, narrower cases, sequenced building up. And I'm just questioning, is that the reality? Or will we just get stuck with smaller and narrower cases, which will be politically convenient for many states parties and for some non-states parties, but it will really rip out the guts of what this whole project was about, which is a court to hold everyone to account, whether you're from a powerful government, a less powerful government, allied with a powerful government. I think we have to have fidelity to that ambition in the Rome Statute. There aren't really easy answers to implementing that, but I think that's why I am really calling on the court's leadership to have that as their vision and their goal, and to do a better job of providing some answers as to how to achieve that practically, because states are not going to be helpful in providing those answers right now.
And just to, woman's plane for a second, I don't think Alex or I meant to suggest that only pursuing smaller cases was the answer. Ideally, if you have, I think you said it already, if you have a large case against a world leader, go for it. But I agree with Alex that empty courtrooms, right, versus pursuing smaller cases, which, I'm an optimist, so I think they will lead to a larger case. I think that's the, better strategy.
Also, to go to Liz's point, I think that if in 25 years or 50 years the court is only doing little cases, then yes, then it's a failure. Then it's unquestionably a failure. But we're talking about today, what the court has to do to prove itself and establish itself, and it still, I don't think, has done that. It has not proven that it can work as a model. And I think the starting point is to show that it can do its fundamental job, which is to prosecute cases. And it has to start doing that. It has to start having cases and show that it can do it efficiently and handle it and not take years and years and years and just do cases.
I don't think, did we address your question on the ad hocs?
No.
We didn't address either of your questions.
Also, okay. Well, my question is whether this is the right model. The ad hocs seem to work remarkably well. Pretty well. And this court with its sprawling agenda is not working, and it's been a fair amount of time, a lot of money invested, and so maybe the brain trust in this room should rethink the whole model. Maybe ad hocs are a better way to go, and maybe there's some way to convert this into a collection of ad hocs. As I say, it's slightly untypical suggestion. But the other question was regarding specifically Afghanistan, and because that's right at the center, certainly, of the Trump administration's concerns. What surprised you, Liz, about that? What is it that you didn't expect?
Sorry, I forgot to answer that. So for me, what was really surprising about that decision was the rationale that the judges articulated. Now, they've just granted leave to appeal the decision, so the story is far from over. But the judges essentially found that the prosecutor had satisfied her burden, that there were crimes within the court's jurisdiction. She had satisfied her burden, which at this stage it's a relatively low threshold, but she had satisfied her burden that there weren't any national proceedings that would cut off the court's jurisdiction. She had satisfied the burden that the crimes were grave enough. But they declined to authorize an investigation because they found that it was not in the interests of justice, which is a term in the Rome Statute. And they found it was not in the interests of justice because given the cooperation challenges, which was really a likely nod to the U.S. position on the ICC, also political developments in Afghanistan, and also given that the court has limited resources, that the likelihood of successful prosecution was so low that the prosecutor would be better off in putting her resources someplace else. And I find that shocking because it really goes to the heart of what the court is about and the reality that the court finds itself in. I think if you're going to require from the outset, there's a lot of debate about whether this is even for the judges to look at, but if you just take the decision, the substance of the decision, it seems like it requires a guarantee of cooperation from the outset for there to be an investigation. And I think that would render the court's I think that would make investigations before the court just a null set because you don't really have guarantees of cooperation. And yet also cooperation is fluid and it's subject to influence in positive and negative ways. So for me, I found that the judges were basically saying something that is a very sort of structural issue. We need to have cooperation before we can go forward, would basically gut the ICC's ability to move forward if that's what a decision about authorizing an investigation is going to hang on. Also, I think the interest of justice, a component of that is the interest of victims. And so they kind of turned on its head a little bit what Todd was saying, that, and there's legitimacy to this, that many victims have been very disappointed by the results that the court has delivered. But the judges sort of seem to use that to say, we don't want to create even more disappointment. So we're just not going to go ahead and even start this investigation. And I think that really kind of turns on its head the idea of meeting expectations, not just doing away with them when it comes to victims' rights to justice.
Can I address the ad hoc point? Which I think the answer is no, that the model is not going to be Yugoslav and Rwanda type tribunals. I think, in fact, the ICC was a response to the Yugoslav and Rwanda tribunals, which were seen as, really relatively successful, but too expensive, that they couldn't be replicated, and that a permanent court with a sort of permanent budget would sort of do better. But I do think that the question about whether there's a, I do think the question raises an important point, which is that what's going to, I think, for this whole system to be successful, what has to happen is, in fact, what's happening which is the development of sort of other mechanisms to fill in more of the pieces of what needs to be done. The ICC, there's a big universe out there of accountability. The ICC, in reality, I think, can only do a small part of it. And that is digestible only if we could sort of find things to at least start addressing the other parts of it. And you do see, sort of more, with all their flaws and with all their imperfections, you do see sort of more, the special criminal court in Central African Republic and so forth. You do see that, and I do think that is an important piece of what's happening. And then with that goes, I think, the ICC sort of articulating a role for itself that has a smaller, I don't know how to put it exactly, where it's not, where what it is thought of as being responsible for is more focused and more narrow, so that it's not, in effect, effectively promising that upon which that it can never deliver. Because I think there will be a limit to what it can deliver, and I think it's fairly narrow.
And let me just, on this question of ad hocs, I just wanted to jump in and say that to me, it's not a question of should we just get rid of the ICC and just have ad hocs. I think there's a particular place for both ad hocs and other mechanisms, and also the ICC. And I also think that, regarding the ICC, the genie is out of the bottle. Rome was 21 years ago. I don't think we can go back. And let me just quote Jim Goldston, who recently wrote this piece in Foreign Policy defending the ICC. And this is what he said. He said, perhaps the most compelling argument for investing in a more effective ICC is that letting it die would deliver a huge blow to the fight against impunity. Flawed as it is, the ICC remains a capstone of our centuries-long search for a world in which the law prevails over brute force. Giving up on it now would set back that struggle immeasurably and would be a great disservice to the many courageous activists who have given their lives for the cause of fighting crimes against humanity and genocide. I don't think that could be stated any better than what Jim wrote.
I wish you'd saved that for a closing comment. Okay, before I go back to questions from the audience, and I will come right back to you, bear with me a minute, I would like to ask the panelists if you would like to give, we're coming up on the selection of a new prosecutor. And the new prosecutor, of course, depending on your perspective, is coming into a very challenging environment. And so I'd like to know if any of you, in some ways this might sum up what some of the comments you've made, but if you were giving the new prosecutor some advice or some thoughts going forward, what would you advise the new prosecutor, say, where should you try to be at in 1 year and 3 years as a new prosecutor coming in? I'll throw that out to the panel.
I'd say talk to David Crane.
Okay.
I'm sitting here, I'm trying to figure out, it's a very difficult question because, again, the two previous prosecutors, who are both personal friends of mine, and none of my comments have anything to do with them personally, but you may have to start over and step back. Yes, there's lots of paper about strategies and every 3 years, what have you. They're really not working from a public perception point of view and from a track record point of view. My thought would be is take a really close look at the office and get a sense of how to reorganize it in a way that gives the perception that there's efficiency, there's effectiveness, and there's a purpose and a direction that, as I said in my earlier comments, my beginning comments, to step away from that malaise that's a cloud over all these great people working hard. Public perception of what you're doing is very, very important, particularly from the victim's point of view. And I'm just concerned about this malaise that I brought up. And I think the new prosecutor, whoever he or she is going to be, is going to have to take a close, honest look at where they are, where they're going, why they're doing it. And if the answer is this is the right way that they're doing it now, that's fine. But if I was handed the mantle, I would step back and ask some very fundamental questions so that we can move forward in seeking justice for victims of atrocity.
I would agree with what David has said about trying to find ways to energize the office, to try to think about, step back and think about how's the office organized, what kind of policies do we have in the office in terms of staffing and who works there and how long you work there, to try to think about how you can bring a kind of energy and urgency to the office. And then the second thing is, I would say to the prosecutor, in your first 3 years, you should say, every single conversation I have should be about bringing cases to the court. That's all I want to talk about. I don't want to talk about speeches. I don't want to talk about reports. I don't even want to talk about complementarity right now. I don't want to talk about motivating others. I don't want to talk about the beacon on the hill. I don't want to talk about any of that. If you come talk to me about that, go away. You should only talk to me about cases. That's all. Every single minute of my time should be focused on that.
I agree with that, and I go back to what I said earlier. I would say that it would be super important for the new prosecutor to bring more cases to the ICC and to bring more cases where there is a realistic chance of a conviction, successful prosecution, in order to rebuild this perception of the court as an ineffective institution.
I'm going to punt on the advice. I'm going to just say that right now there's actually a lot of discussion among states parties and among civil society following the court about what can be done to address some of these issues of performance, of lack of support, of improving the elections of officials. And one element that I think will be really important and I think will provide a tool for the new prosecutor coming in is if there is an assessment done by a panel of independent experts who could look at why are we having these problems? There are ongoing investigations in Georgia, open now for 3 years. There's no public arrest warrants. Why is it taking so long to get those courtrooms full? What are the factors that are within the control of the Office of the Prosecutor? What are the factors that are down to states parties and others? And I think having this independent assessment, if it's done right, if it's done by experts, and there's some examples from the Special Court for Sierra Leone, examples from the ad hoc tribunals, it could create a really important common reference point, a tool for the new prosecutor coming in to see what kind of changes are needed, but also a really transparent basis for all the stakeholders in this system. As Jennifer said, it really is much more than just the court itself, to really chart the way forward, to have greater successes in the courtrooms than what we've seen so far.
Okay, I'm going to start. Yes, I'm going to start back in this corner, and I promise we'll get. Okay.
Sure. Thank you to all the panelists. I guess I was a little surprised that I haven't heard so much, and maybe this has been a long-held critique of the ICC, but of its particular, perceived at least, African bias. It's my understanding that every conviction has been of a member of an African country. And so it seems to me it's quite a striking disparity, and one that's been noted by many scholars and critics. So I guess just be curious what the panelists have to say on that. And I guess relatedly, I certainly see the appeal that I think Alex and Milena brought up about sort of going for low-hanging fruit. But I guess that should obviously be done, and I don't doubt that both of you would subscribe to this, very thoughtfully and deliberately in terms of whom those individuals are, because then I think you may have similar issues as I began with in terms of at least a perception of unfairness, discriminatory justice.
Okay, let's take next question.
Thank you. I have to confess, Professor Avikova just asked my question literally, but I'm going to try to spin it in another angle. Professor Johnson and to the entire panel, I think just to go back to the question, the African issue question, I'm a passionate African and I respect what the court, the court's role in the continent itself. But I cannot shake off that bias, the perception of the bias, in terms of what role, the court is playing because all of its convictions so far have been for African leaders and things like that, So my question to you all, I think, former prosecutor of my beloved country, I think David Crane mentioned it about the political question. I know my continent has not produced a legal or procedure question to go against the court, but all of the arguments, based on my research, have been based on the politics behind, raising this case or bringing leaders in front of it. So my question would be, how do you think the court can shake off this malaise? Because it is time that the ICC put forward a coherent strategy to answer this question, because countries are withdrawing, countries are moving out. Burundi, there is also a talk, like Professor Johnson mentioned, about South Africa, and other countries are really thinking about leaving the court. So my question is, how can the court shake off this malaise? Because as young African, these are questions that we face every day. So I just want to know your own opinion. Thank you.
Okay, who would like to, let's go ahead and address the African question. Who would like to do that?
So there's a wonderful, really funny cartoon that I saw that some of you might have seen also, and it's basically a map of Africa, and then there's Prosecutor Bensouda with the magnifying glass walking around Africa, and then there's like a cynical caption that says, "But the ICC investigates throughout the world," right? So yes, there is this, at least perception of a bias and, investigations taking place only on the African continent. And I would say that going forward, the relatively recently launched Rohingya investigation, so not a case coming from Africa, and perhaps future cases that involve situations that are not on the African continent might be the best way forward, might be the best way to combat that, perception of anti-African bias.
Your others was more of a comment than a question, wasn't it, on taking the low-hanging fruit?
Well, guess I'll plead guilty to that, but I don't know if that was viewed as salient.
Well, I think you said the low-hanging fruit, if you take the low-hanging fruit, it could be unfair. It would be unfair. That's right. There's no question about it. But that's the reality. The court, if the court prosecutes low-hanging fruit and can't prosecute the senior people, that's unfair. That's right. You're right.
That's actually not my concern about fairness. It's that it goes more to, I think, the political question in terms of, where are those low-hanging fruit from? And so the risk being, if you're not thoughtful and deliberate in whom are the low-hanging fruit, then I think you can run into the same concerns, whether it's an African bias or other biases.
Yeah, that's I think that's a fair concern, and I think the court has to be sensitive about that. And so I think somebody else said that if you do the smaller cases, I don't remember if it was somebody on, maybe somebody even on the panel, you have to be very thoughtful about it, and there are risks to that strategy. You'd have to pick the right people from the right places and be sensitive to all these other concerns. That's absolutely right.
So I have a question for the panel. I think we focused a lot on the prosecutor. I would focus on the judges if I was looking for problems, and I would also eliminate the pretrial chamber. And I would completely eliminate the confirmation process, because the confirmation process is designed to make the ICC work badly. That's how it's actually working. And so I would ask all of you, why not just get rid of the confirmation process? Because the ad hocs didn't have this. So Roy, to go to your question, the ICC has a completely different procedural structure. And it works very badly in a lot of ways because it was intended, in my view, by states to slow the court down. I don't think the states wanted a court that would be fast, efficient, effective, impartial. They were scared to death of the ICC. And so they created an extremely heavy and bureaucratic system. So why not just get rid of the confirmation process, get rid of that third phase of the thing, which is slowing everything down? And what can we do about attracting better judges?
I think that's a great question. I think the Achilles heel of the entire modern international criminal law system are its judges. They were a constant problem in West Africa, and they are problematic throughout all of the tribunals. It's getting better, but it was a disaster at the beginning, and many of them are still, quote, in the system. So I couldn't agree with you more. It's probably the biggest problem of the system is the selection of judges and the type of judges that we have currently on the benches. So I couldn't agree with you more. And absolutely get rid of that whole selection process. The prosecutor, you know, I had the luxury of, like any prosecutor, I drove the train. I decided who, what, when, where, and why based on my strategy, and then I handed it to the court saying, all right, let's try this case. Fatou Bensouda just doesn't have that capability, and that's got to be incredibly frustrating, and we've seen some real problems were related to that, and they've gotten themselves into some very serious, both legal, but also just practical and political problems that have embarrassed the court, which again feeds this aura of ineffectiveness and inability because of that one thing. And if I'm not mistaken, correct me if I'm wrong, wasn't it the United States that really pushed this at Rome, ironically?
Confirmation?
No, yeah, the whole pretrial chamber thing, wasn't the United States was really driving that train? And the French. Oh, and the French. But the point is that that was, in fact, that was one of the preconditions for the United States to even sign, or at least agree to the Rome Statute at the time, was this process. Because they were worried about an unrestrained international prosecutor who could bring down a head of state. I mean, that was really their underlying concern. So it's a great point, and but again, the practical reality of it is we'll never get that changed. You know that. If we reopen the Rome Statute for revision, I know we meet they meet every 7 years to take a look, but I don't know. Do you think based on your long-term work with the court, do you think they'll actually there be enough interest to do away with that, the pretrial?
Can I speak up in favor
Sure.
of it?
You left just before you turned around.
Yeah, well, please, yeah.
No, I mean, actually, I hope also looking at this could be one of the things that this independent panel could do. But I would just say, and David, you suggested we talk about it, and we haven't really talked about it, the system of victim participation at the ICC. And I think there is actually potentially, or there is, it could be better, an important role for victims at the confirmation of charges process, at that stage, because the way the court's case law works, if you are not a victim of the particular charges that then go to trial, your procedural rights drop out. And so I think it is important to make sure, or I think that there's a potentially, obviously many people also talk about the confirmation of charges as being important for defense rights, but it can be a moment of really significant participation for victims at the court. So I would just want to have that in the mix. I don't know if that outweighs the concerns in terms of efficiency and length of proceedings.
Okay, we're down to about 3 minutes, so
Hi.
right there. So I have one right there and one in the back, but you got to be quick.
Okay, so I just have one comment, and I'm really grateful for Professor Avi for bringing up the issue of diversity and the African bias. And I feel like the focus on, and maybe provide a little bit of pushback to what Milena said. Now there's, Rohingya in the Philippines, for example, so there's no more African bias, but actually it's just another version of the African bias. And I don't think that response adequately addresses the question. And I'm not anti-ICC, but actually I feel like, I've been sitting here for the past hour and a half, and I've been thinking, is it a structural issue in terms of hiring policy, like what Professor Whiting said? Is it a problem pervading the field generally, where the experts, academics, policymakers come from a specific portion of the globe? But I do think that more people from the places where these preliminary examinations are happening should be onboarded. That's exactly what, and I think that has a very concrete impact on political will. And if I can talk briefly about what happened in the Philippines, when the drug war, when the ICC prosecutor announced that they would conduct a preliminary examination of the drug war, no one knew in the Philippines what the processes were. And I had to explain in newspapers, I had to write op-eds, what these processes meant in the domestic system. And we even had ordinary legislation that enforced the Rome Statute in the Philippines. But you see, you see how the people in a specific country affected by a situation, actually, it has a lot of impact on the political will. So when Duterte said, I don't care about this ICC, let's withdraw. And in fact, there was a brief mention about withdrawals. No one discussed or mentioned the Philippines. We were the country that most recently withdrew from the ICC this March 2019. And it makes me wonder how easy it is for a country to withdraw when its own people don't even know what the ICC means for them.
You know, I think you bring up a really good point real quickly. The perception is from other countries other than from the West is that all of this is Western justice. In some ways, it's white man's justice. And I think we have to ask this question, and some of you in here have heard me ask this before. Is the justice we seek the justice they want? And we tend to step over that question and do our own thing, and we miss the point from a cultural point of view. Is there a cultural approach to international justice? I'll just leave it at that.
Okay, we have yes.
So given the state of the world, perhaps this is a question of the future, maybe even a utopian one, but Alex brought, too bad he is leaving, brought up, I know, then the panel might save you. He brought up that he wants cases, only want to talk about cases, but the panel in general is asking for more action. However, the title of our event is Atrocity Prevention. In an ideal scenario of world peace, we would have very few atrocities, if any. So how does that align with the ICC's need for more cases, and Alex's too?
Would like to take it.
What Alex would have said was, I think what Alex would have, he would have said it more articulately than this, is that at the stage we're in now, there's plenty of cases that you could choose from. And of course, the goal is a sort of world without atrocities that we would build towards. I don't think he would permanently, I don't think his goal would be a world with a lot of cases that he could prosecute. But I think what he thinks is that we need to have sort of more prosecutions now for the court to say its footing underneath it.
And I would just to follow up on your comment, I mean, I didn't mean to suggest that like now the Rohingya case is the answer to all of this. It's not, but it is a first step. It is a non-African case, and there ought to be cases from throughout the world in the ideal sense, absolutely. And I actually agree with you that one of the other criticisms of the court is that it needs to have more in-country expertise for all of the situations that it is investigating, so that ideally it really needs to work with people who are from the country and develop a more in-depth country expertise and perhaps do better outreach, right, to explain what it is doing and why it is investigating.
And just to add on to that and to bring it together with the last comment, because I also had wanted to say that I think that the need for the court to be able to root itself more deeply in affected communities and spread awareness about what it does and what it doesn't do and create that sense of ownership. And there are very strong efforts by civil society in the Philippines to push back on withdrawal, but there needs to be more. I mean, there can just never be enough explaining and listening and learning on the part of the institution. Again, though, what a challenge for it to be able to do that, to find the resources to only talk about cases while also doing the kind of public information and communications that are actually needed for court that, you know, there's really no reason. Why would anyone just accept that I mean, you don't just turn up and have instant legitimacy. You have to build it. And I think there has to be a recognition that that's got to be part of the workload as much as we might also want to only focus on investigations and prosecutions.
Thank you.
In the course of this long day, we've thanked the different organizations and different people, including the panelists, but there is one group who have been behind the scenes making all of this work so well, and then will start their really difficult task soon, where they start editing and footnoting and site checking the articles that will all come out. Jody, can you come on down for a second? This is Jody Aramband. She is the editor-in-chief of our Journal of International Law. And is there anybody else in the journal that's here that, can I have you guys stand up and be recognized? So, do you have anything you want to say to the panelists about the process or anything?
I just want to
say thank you to all of you for being here. It is a privilege to meet you and get to hear your thoughts today, and I very much look forward to reading all of your work. Thank you for submitting your work timely, and for those of you who asked for extensions to modify your pieces because of these conversations, I look forward to reading those too, and thank you so much.
Thank you, Jody. On your way out, Eileen Drabowski was the administrator who made all of this work. Please give her a thank you, and we hope you guys will all be coming to our many conferences and lectures that we have coming up. There are these Case Global magazines on the table out there. It has the list of all of our upcoming events. They're also online, and we look forward to seeing you at the next one. Thank you all for being here, and thank you, panelists.